let me bring in my special guests. I'm joined this morning by criminal defense attorney Paul Townsend and also criminal defense attorney and former prosecutor Brian Silber. It's great to have you both here. Brian, I'll start with you because my time is limited with you. You didn't want to stay longer like Paul did. It's fine, not insulted. What did you take away from the forensic pathologist, maybe that you didn't know before and that maybe helps the jury as they continue on in this case?
So I'm going to say something a little controversial, and I'm almost afraid to say it because this guy is hated so much. But I really think there's reasonable doubt in this case, and I don't know if I'm a juror, am I going to convict him? Couple things. The answers I'm not hearing is there a match of the ammunition that they found with these victims, and does it match the firearms that he allegedly owned? A shotgun, depending on the type of shotgun, will expel a spent shotgun shell after being fired. Not all of them are like that, but a lot are. And I wonder if he owned the type of shotgun that would expend a shell, and if it does the ammunition, if there is any found on scene, any shells found on scene, does that match what he owned or what was found in the house? And the reason why I have all these questions is I'm thinking more about the gun residue evidence, how skimpy it was. I remember the expert testified they found one single particle on one of his hands. And to me, I fired a shotgun many times. I've been to the gun range quite a bit, actually, and I get filthy. I just can't imagine he discharged a shotgun at least twice after firing another rifle, and they found one single particle on him. You know, this is a guy that...
Well, they did find GSR also on the shorts and the shirt as well.
Yeah, but it's nominal. It was very little. It doesn't seem to the level of what we're talking about. And, this is a guy that really wronged others. There were a lot of people that had a lot of reasons to inflict, harm on him and take something from him like he took from them. I'm not saying he's innocent. I'm saying there's a major question here. And that's what these trials are about.
And if that question is reasonable doubt. Okay. So, Brian, I'll go back to you on this. As we listen to this evidence, in your opinion, right now, what are the strongest pieces of evidence put forward by the prosecution? Because sometimes the prosecution puts into evidence not necessarily to show that Alec Murdaugh did it, but it's their burden. They have to show all aspects of a case, right? So maybe even the forensic pathologist might not be able to definitively help the jury determine who did this, but there is a part where you have to say there were killings that took place, there were murders that took place. You have to establish that the two victims are in fact dead. What, in your opinion, is the strongest evidence so far put forward by the prosecution?
Oh, without a doubt, it's the evidence of the financial crimes. I said the last time I was on that I thought that evidence was way more prejudicial than it was probative. And I think that's really the only thing that really glaringly speaks out to say that there's a major question about this guy. But, the lack of defensive wounds in this case, to me, doesn't move the needle at all. Let's just assume the crazy theory for 1 second that this guy is actually not guilty of this murder. What if two offenders were waiting for the wife and the son in the home, armed with two different firearms, and held them there at gunpoint? They're freeze, I got you, and then they murder them. They wouldn't necessarily have defensive wounds. It doesn't mean that there was a struggle. They could have been shot at a distance. It could have been very cool, collected, and calculated. Everyone assumes there had to be a struggle, and because there was no struggle, it had to be him because they would have known him. Yeah, that's a possibility, but it doesn't mean that's the only possibility. You understand what I'm saying?
Yeah, no, of course.
I can't see anything here that really moves the needle conclusively. The worst thing here is that he did these horrible financial crimes.
Well, I don't know. See, Paul, I'm not sure. Look, the financial crimes definitely helps the prosecution, and it was a big blow for the defense that was led in.
Big time.
Okay, that motive makes more sense to me when I hear about what was happening. All right, let's take a break. When we come back, we'll get into some more of the forensics here on Law and Crime. Stay with us.
And this courtroom here is full of people. Could anybody in this courtroom have those same three alleles present in that testing?
It's possible.
Brian, how significant is that? How significant is that to find that level of substance or material underneath the fingernail?
So I think this helps the defense because either it means nothing, she had someone else's DNA under her fingernails. Could have been was scratching the back of her nephew. or maybe she, who knows, it's somebody else's DNA. So or it could be defensive. Maybe she scratched at her attacker. And if it doesn't match anybody in the house, well, that includes our defendant. And it aids the defense's theory that he wasn't the one who killed these people. I don't see how this evidence helps the prosecution, not to mention the fact that cross was great. There's a lot of unanswered questions here. And I think every time the prosecutor puts a witness on who gives an answer like that, it hurts the credibility of their case, even if it doesn't necessarily establish a defense.
Okay.
It just shows that there's holes here.
Look, I will agree with you that I think that what the defense has done really well is suggest that there were deficits in this investigation. Even talking about an officer walking through the crime scene and leaving bloody footprints. Before we hit our break, Brian, I'll give you an opportunity to respond to that.
Yeah, that's the problem with this case. And the more I watch this trial, I feel like we're dealing with a situation where there was some decision that he was the offender who did this, and then they conducted their investigation around that theory to find evidence that supports the theory, as opposed to being truly objective and following every lead possible and what it tells us. They built an investigation around him instead of around the crime. And we see this a lot in criminal defense. For some reason, law enforcement is convinced that they found the killer, and now it's a matter of getting the bad guy, so to speak, as opposed to truly solving the crime. And, that's just the human element of criminal investigations. But in this case, I think it might translate into a not guilty verdict because it creates reasonable doubt.
Okay. Well, I'll tell you what. We are going to cover this together. We're waiting to jump live. We'll see where the prosecution's case goes next. Stay with us here on Law and Crime. We'll be right back right after this.
Swabs from side openings, zipper area, and both interior portions of exterior pocket of the blue raincoat.
Okay, so Brian, we know there was GSR on that raincoat, right? But there's no blood on the raincoat. Again, we cannot definitively say if that was Alec Murdaugh's or he stashed it there. But you remember what Shelley Smith, the caretaker for his mother, said, is that she saw him carrying a blue tarp. Prosecution says she meant blue raincoat. If the jury accepts it's a blue raincoat, what do we make of that coat?
I think it just raises more questions again. These are just more holes in the prosecution's evidence line here that the defense is going to harp on. How is it a guy has GSR from shooting two people multiple times? Okay, that's what they're going to tell me. That's the value of this raincoat. But there isn't a single drop of blood, and a shotgun was used, and a person was shot in the head and in the chest. I mean, that is an extremely bloody crime scene, and it just makes no sense. It doesn't add up to me. If anything, it substantiates the defense theory that if there is GSR, he picked it up from rubbing against them or rubbing against some other source that is unrelated to the act of murder in this case. I'm just not convinced, and I see reasonable doubt at every corner here. And again, I'm not saying he's innocent. I'm saying that the prosecution is not proving this beyond a reasonable doubt.
On purely the wounds and trying to figure out how that happened.
Yes, so I basically, I do the autopsy, I have everything to do with the body, and at the time, I never heard anything about, I've composed my autopsy report.
All right, Brian, we think this cross is going to last quite a bit. Where do you think Mr. Harpootlian is going right now with this?
So, as a trial lawyer who's seen a ton of shootings, I mean, more than I care to, I just don't believe in this type of testimony. To speculate about the person was positioned this way, they were turning that way, the shooter, you know what it reminds me of? It's like we're passing a car accident on the side of the highway. There's some vehicle flipped over, crushed like a tin can, and based on how it's positioned and the damage to the vehicle, we're going to figure out what caused that accident. I'm sorry to say, but that's purely speculative, okay? Every time she says probable, I hear reasonable doubt. Probable has no place in a criminal trial. We need more evidence than that. The truth is, yeah, they got some clues here and there, but they don't know what happened. They don't know what she circled, what she bent over. There's no clue.
The only response I'll give to that, Brian, is you're dealing with people of science. And when you deal with people of science, they never like to be definitive as much as we need them to be. Brian Silber, thank you for taking the time. I appreciate it. Next time, come on longer. We'll be right back right after this.
Absolutely.